This is your testimony dictation for week number 9. I'm sorry, not your testimony, your jury charge dictation for week number 9. Ladies and gentlemen of the jury, as I stated before, the burden of proof is on the plaintiff in a civil case such as this, to prove each basic element of his claim by a preponderance of the evidence, period. A preponderance of the evidence means such facts, when viewed and compared with that opposed to it, that have convincing force and produces in your minds a belief that what is sought to be proved is more likely to be true than not true, period. In other words, to establish by a preponderance of the evidence merely means to prove that the claim is more likely so than not so, period, paragraph. To determine if a fact in issue has been proved by a preponderance of the evidence, the jury may use the testimony of all the witnesses, regardless of who may have called them, and all the exhibits received in court, regardless of who may have produced them, period. If the proof in this case should fail to establish any essential part of the plaintiff's claim by a preponderance of the evidence, the jury should find for the defendant as to that claim, period, paragraph. The evidence from which you are to decide what the facts are consists of the sworn statements of witnesses, both in court and by depots, no matter who called the witnesses, the exhibits which have been received in court, and any fact to which all of the lawyers have agreed to, period, paragraph. Now, in this case, you may use only the testimony and the exhibits received in evidence, period. Some things are not evidence, and you may not use them in deciding what the facts are, period, paragraph. Statements made by the lawyers are not evidence in this case at all, period. What they have said in their opening statements or arguments and at other times is only to help you interpret the facts, but it is not evidence, period. If the facts, as you remember them, differ from the way the lawyers have stated them, your memory of them controls, period, paragraph. The questions asked by the lawyers are not evidence, period. Attorneys have a duty to their clients to object when they feel that a question is improper under the rules of evidence, period. You should not be swayed by the objection or swayed by the court's ruling on it, period, paragraph. Testimony that has been stricken or that you have been told to ignore is not evidence, and must not be considered, period. In this case, if exhibits have been received only for a limited purpose, you must follow the limiting instructions that I have given you, period. Paragraph. What you may have seen or heard when the court was not in session is not evidence, period. You are to decide the case solely on the evidence received at the trial, period, paragraph. You were instructed not to listen to anything about the case on TV or to read anything about the case in the paper, period, paragraph. In deciding what the facts are, you must consider all the evidence, period. In doing this, comma, you must decide which persons to believe and which persons not to believe, period. You may disbelieve all or any part of any witness's testimony, period. In making that decision, comma, you may take into account a number of things, colon. Was the witness able to see or hear or know all the things about which he testified, question mark, semicolon. How well was he able to recall and describe those things, question mark, semicolon. What was his manner while in court, question mark, semicolon. Did the witness have any interest in the outcome of this case or have any bias or prejudice toward any party or any matter involved in the case, question mark, semicolon. Was the person's testimony contradicted by what that witness has said or done at one time or by the statement of other witnesses or by other evidence, question mark, paragraph. In deciding whether or not to believe a witness, comma, keep in mind that people may forget things, period. You need to decide, comma, then, comma, if a conflict is simply a memory lapse or is it a lie, period, paragraph. You have heard testimony from persons described as experts, period. Persons who have become expert in some field by training and experience may state their opinion on matters in that field and may also state their reasons for the opinion, period, paragraph. An expert opinion should be judged just as any other testimony, period. You may accept it or reject it and give it as much weight as you think it deserves, comma, considering the person's training and experience, comma, the reasons given for the opinion, comma, and all the other facts in the case, period, paragraph. In this case, comma, certain charts, comma, graphs, comma, and summaries have been shown to you in order to help explain the facts in the books, comma, the records, comma, and other documents which are in evidence in the case, period. These charts and summaries are used to help you, period. They are not themselves evidence or proof of any facts in this case, period. If they do not correctly reflect the facts and figures shown by the evidence in the case, comma, you are bound to ignore these charts and books and determine the facts from the other evidence, period, paragraph. If there is more than one defendant in this suit, period, it does not follow that if one is liable, comma, all are liable, period. Each person is entitled to a fair consideration of that defendant's own defense and is not to be prejudiced by the fact, if it should become a fact, that you find against another of the defendants in this case, period. Unless otherwise stated, all instructions given here apply to the case against each of the defendants, period, paragraph. It is essential that you remember exactly what is evidence in this case, period. The arguments of the lawyers are not evidence, and they must not be thought of as such, period. Remember that your memory of the facts is the only thing that controls, not the argument of the lawyers or their statements, period, paragraph. I will send you to the jury room for deliberation in a few minutes, period, paragraph.